I want to commence by acknowledging that we're meeting tonight on the land of the peoples of the Kulin Nation and to pay my respects to their elders past and present and to their emerging leaders also. I also offer a very warm welcome to any Indigenous people who are joining us for this evening's conversation. Good evening and welcome. And I do want to say that in my heart of hearts, I am very excited to be looking at a room of real people here for a real conversation between Professor Ken Hayne and Ms. Thea Stephenson. I thank you for coming and I thank you for being here, and we look forward to the evening rolling along and then to engaging you in conversation. For those of you who don't know, I'm Pip Nicholson and I'm the Dean of your law school. You will shortly hear from the Honourable Kenneth Hayne, ACQC, and Thea Stephenson, President of the Melbourne University Law Students Society. And as I mentioned previously, following their conversation, there will be an opportunity for questions. Before I introduce the conversationalists, I want to deal with a few matters of housekeeping and then make a few preliminary comments of my own. I do ask you, if you have a mobile phone with you, if you could please turn it off. We are filming this evening's conversation and a recording will be on our website in the fullness of time, not usually that long. I am reminded to remind you that if you feel unwell, please feel able to leave. We are in a wonderful place in Victoria that we can come together for lectures like this, but we must be mindful if we feel unwell of the advisability of vacating. Today's conversation will be uncomfortable for some. Everyone in this room knows that we are sitting as a group that includes women and men who may have been sexually assaulted in some way. And so I encourage you, if you are a student and feel any anxiety or distress as a result of the conversation that unfolds, to be in touch with either the University Counselling Service, a trusted friend or colleague, or indeed Safer Communities at the University of Melbourne. And for staff, you can also reach out to the staff counselling and support services. I now want to say a few words about this evening's topic, and I want to say them to you as your Dean. We have a duty at the university to make sure that it is both a safe workplace and a safe study place. And as many of you would know, in 2016, the Australian Human Rights Commission released its report, Change the Course. The survey results show that half of all university students, 51%, were sexually harassed on at least one occasion in 2016. This is a devastating report. The data is now dated and the investigation into sexual harassment on the campuses across Australia will be continued with a further survey taking place in September 2021. At this university, a new sexual harassment policy is currently under development. At this time, any student who has experienced inappropriate, concerning or threatening behaviour, and including sexual harassment, should seek support. And that support is available to you through Safer Communities. If we look beyond the tertiary sector to the legal sector, we note that in 2019, the Victorian Legal Services Board and Commissioner undertook a review of sexual harassment in the legal profession in this state. And as Fiona McClay reported last year, when she was here in conversation with me, that sexual harassment and predatory behaviour is very widespread in the legal profession, and it reflects systemic sexism, in turn reflective of entrenched power imbalances. I refer you to that report, and I note also that Victoria Legal Services Board and its Commissioner are in regular contact with this school, and they are keeping us appraised of the developments that they are enabling, new mechanisms by which young lawyers can report sexual harassment, noting the development of the law now includes the fact that sexual harassment is a breach of both ethics and a range of other statutory instruments. We have a long way to go. The situation is far from resolved, but work is ongoing, and I know that Fiona would encourage me to build a bridge between you and the work of the Commission as you go out into the workforce. At the Melbourne Law School, we respond to the challenge of a safe workplace and a safe study place in various ways, including encouraging our graduates to take responsibility and see how they can build cultural change in the diversity of workplaces to which they go. I met with the graduates of 2020 in March. It was their opportunity to return to the school, having, as you all know too well, spent 2020 at a distance from the school. And in my address to them, I asked them to carry with them, to the best of their ability, men and women, and all genders, the capacity to drive change as new recruits into the legal sector. And I will no doubt continue to remind graduates of what I see as the necessary cultural change being driven not only from the top, but also from the newest entrants into the legal profession. The law school's also working on training in consultation with the Legal Services Commissioner, having received advice from VicBar, the Victorian Bar, and on how best to train you as you go into both clerkships, graduate positions, but also as you go into internships, very widely dispersed across a great many different organisations within the legal sector. Concurrently, we work to debate the issue of sexual harassment with you and between ourselves. We are lucky at the school to have some leading scholars on law reform in relation to the gendered nature of law, one of whom is with us tonight, Professor Jenny Morgan, but Professor Beth Gaze is also very active in her research and scholarship in this area, and so too Professor Heather Douglas. Tonight, therefore, continues a conversation that we commenced last year as a result of certain events at the High Court. And that conversation is about the predatory behaviour in the legal sector. I specifically asked Ken Hayne to join Thea Stephenson in conversation. I did that because I wanted to hear from those, and I hope you'll excuse this, at different stages in life, at different stages in their career, and also of different genders. I thought it critically important that we hear from your generation, and Thea, I thank you for responding to my invitation, and a leading jurist, Ken Hayne. And Ken had also contributed to the public debate, and he's actively involved in the Victorian Bar Readers course on the topic of tonight's discussion. Last year, some of you might know, we had a virtual seminar at which Fiona Macleay, the Legal Services Commissioner, spoke. Jennifer Bertruni spoke as the then past president of the Women Barristers Association, and Josh Bornstein from Maurice Blackburn spoke, who is an active advisor of those who have brought complaints about inappropriate behaviour in the workplace. So, I've framed tonight's conversation. Let me now very briefly introduce our speakers. Professor Hayne is a former Justice of the High Court of Australia, where he served for 18 years, retiring in 2015, and subsequent to that retirement, joining us as the Judge in Residence. Prior to his appointment to the High Court, he was a Judge of the Supreme Court of Victoria from 1992 to 1995, and a Foundation Judge of the Court of Appeal of Victoria upon its establishment in 1995 and through to 1997. More recently, and I think perhaps much more publicly than some of the earlier parts of your career, Professor Hayne led the Royal Commission into the misconduct in the banking, superannuation and financial services industry. And that Royal Commission ran from December 2017 until February 2019. Thea is a current third-year Juris Doctor student at MLS. She's also the current president of the Melbourne University Law Student Society and previously held the position of Women's Director for the Law Student Society in 2019-2020. She was elected as a president in part on a campaign which centred on addressing sexual misconduct within the profession, and has been highly active in her discussions with me and with others since taking up the presidency. Ms. Stephenson completed her undergraduate degree in Gender Studies and Criminology at this university and is co-founder and director of Legalese Solutions, a legal administrative support services startup. I welcome you both very warmly and I look forward to your conversation.
Thank you, Pip, and thank you everybody for joining us this evening. I would also like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of the land on which the law school stands. I would also like to acknowledge that Indigenous voices are ones which are often left out of the conversation of sexual harassment, and yet Indigenous persons have long been victims of sexual crimes within this country. I pay my respects to all of those who have suffered at such crimes and extend that respect to any survivors here with us tonight. Welcome, Professor Hayne.
Thank you.
I think Pip initiated this part of the conversation, but I think it's nice for us to reiterate it as to why we are the ones sitting here tonight speaking about this topic. When we met to discuss what we wanted to cover in this evening's presentation, we talked about the fact that we are bookends of an intergenerational issue, one which is not going to be fixed or changed without active work from all sides. And that includes men, and it includes women, and it includes those who do not define themselves within the normative gender binary. These conversations have to happen in different spaces and with different people in order for everybody to be heard, but also for everybody to listen. Pip, in all her wisdom, when organising this evening, recognised the fact that having a young woman speak on this topic is important, but having a justice come and speak to members of a law school community is equally important to ensure that more attentive listeners come and attend these events. So I'd welcome Professor Hayne and ask if you have any words.
Thanks, Thea. Why am I here? Well, one, I was asked to come here and I thought I should do so. But I do think it very important that senior men in the profession stand up and say, enough. This has to stop. And unless senior men stand up and say that and repeat it and keep saying it, there is a risk, I think a probability, that the immense problem that the whole legal profession faces will continue unchanging. At the end of the day, the culture of the profession has to change. So too does the culture of almost every workplace in this country. For if you look at the Respect at Work report of March 2020, it is shown conclusively that sexual harassment occurs in every industry, every location, at every level. But those of us who are associated with the law, those who are starting out, those who, like me, I would like to say, are finishing, you would probably say, have finished, have to stand up and say, enough. This must stop. So, that's why I'm here.
And for my part, it's disappointing to hear young women speak about the fact that they come to the law to address women's issues. And then when we are at law school, we learn what the reality of being in the legal profession can look like for so many of us. Because statistically, there are more of us who will be victims of sexual harassment than not. And it speaks to that in the fact that although women make up most of the graduates of law schools across the country, by the time we are into our degrees, we make up much less of the professional working class. And I do not think that that can be solely attributed to family obligations or changes of heart. I think it has something to do with the fact that we are not entirely welcome in these spaces, and we're made to feel like we, in some way, have brought that upon ourselves.
This question of attribution of, I don't care what you call it, fault, blame, shame, to the victims of sexual harassment is one of the recurring and most deep-seated difficulties that we have to grapple with. It will be, I suspect, the hardest thing to change. To recognise the undeniable truth that it is the perpetrator of harassment who is responsible for his, and I say his, conduct advisedly, and it is not the responsibility of, it is not the shame of, it is not caused by the victim of that conduct. The notion that somehow the victim of wrongful conduct is responsible for what the perpetrator has done needs only to be stated to be seen to be as flawed as it is. Yet shame, yet fear on the part of those who suffer this conduct is all-pervading, all-corrosive, and entirely misplaced. Let me expand that just a little. Think of the excuses so commonly heard when a perpetrator is confronted by an allegation of sexual harassment. The excuses usually take one of 3 or 4 forms. Oh, it was just a joke. Bracket. The victim didn't understand, it's the victim's fault. Oh, yeah. Oh, it was just a bit of flirting. Another variation on the victim didn't understand, it's all her fault. I'm a tactile sort of person, you understand. Well, that can be translated as, well, she made me do it. Now stop and think about the content of those commonly heard excuses. They are nothing but a reassertion of the power imbalance that lies at the very heart of the conduct that we are trying to stop. Sexual harassment, like I would say all forms of sexual offending, finds its cause in power imbalance. It is a reflection of power imbalance. That power imbalance, much more often than not in the legal profession, is evident. It is evident from the fact that the profession is stratified. It is stratified in terms of position and responsibility. And the excuses we hear for sexual misconduct, sexual harassment, are excuses that are nothing but the restatement, the reassertion of, the emphasis of the power imbalance upon which the perpetrator relies. Why do I say on which the perpetrator relies? Because the perpetrator acts as he does in the belief that there will be no disadvantageous consequence from his acting or speaking as he chooses to act or speak. And that is, again, both born of and reflective of the power imbalance that lies at the heart. If notions of power imbalance are notions that you find not appropriate to explain it, well, I suggest you look again and think again about it. But let me put it in terms of sense of entitlement. I can, therefore I will. If complaint is made, she made me do it. Now, how do we start to break down the culture that yields that sort of behaviour, that yields that sort of attitude, that yields that set of beliefs? Yes, we need thoughtful, careful complaint mechanisms, because of course we need them. But we also need to come at the problem from the other end. We have to stop the behaviour happening. And to stop the behaviour happening, we have to change the culture of the community within which the behaviour is occurring. Now, I'm talking too much. Thea.
On the topic of shame, I think that it's a burden that all of my female peers wear, and some beyond that as well, but we know that it is statistically an issue which impacts on women most. And it is a burden that we carry, whether or not we realise it, in our own sense of self and in our position within the profession and within our cohort. We know that we are privileged to be here. That doesn't have to be said. But we also sometimes lack the understanding that to be a lawyer and to work within the legal profession is privileged in a way that we can't understand because we're right in it. And when people look at our profession and they see that this issue is rife within it, How are they supposed to trust us to help them with their shame and with the burdens that they carry from their own experiences when they have not been taught the language that we have, when they have been not given the autonomy of the education and the advantages that we have to go through life in a way where we can compartmentalise those issues and not make them our entire identity, when we can still sit in front of a room of people and speak on this topic because we have that advantage. How do we best address the fact that those people look to us for support and for guidance, and yet they are seeing us commit the same acts that they have suffered from themselves? Where is the trust in that system? Where can we trust our fellow peers? If we cannot trust one another, how can broader society trust us to help them? And I think that that comes down to the root of most legal problems, but most often in this instance, because it's personal on a level that not all legal problems are. I think that the idea of shame and this burden and this idea that it is something that everybody has to tackle comes down to unlearning behaviours, not just learning behaviours. It goes in the form of supporting others, but also being critical of yourself where it need be, and ensuring that we are always doing the most to address our own inadequacies in this space. Even as women, we have a role in unlearning the things that we let go of, in building up and understanding that there is no shame in the things that have been inflicted upon us, and that it is our right and our advantage to be in this space, to be the educated young people that we are, to be able to speak up and have the words to stand in solidarity with one another so that we can stop handing this shame out across every single profession that there is. We don't just have to do this for ourselves, we have to do it because it's institutional in every institution. It's not an us problem, it's a world problem. And if we are supposed to be the ones who help to address it and change it, then we really need to start looking at ourselves and doing something about it, because it's not good enough.
Can I just build on this, I think, key problem of how do we address the fact of shame that presently pervades this issue. Could I introduce it by going back a little, just to explain why I've got into this space? The Chief Justice made her statement in June 2020 about the investigation at the court. That day I wrote to all of my former associates. There were a cohort of 36 of them who worked in my chambers, and I wrote to them, A, drawing their attention to what the Chief had said, but B, saying, is there anything I can do? Do you need some help? That led to long and elaborated discussions with some of them. Some of them just said, yeah, thanks, no, in effect, nick off. But it led to long and very detailed and useful discussions, particularly with three of my former associates. One based in London, one based in Sydney, one based in Melbourne. And one of them, at the end towards the end of these conversations, said, all I ask of you is that you use whatever moral authority you have in the profession to bring about cultural change. It was a message that focused the mind more than just a little. So by July 2020, after particularly talking with the former associate in Sydney who's at the Sydney Bar, and the former associate in Melbourne who's head of a large provider of legal services, led to me writing to the presidents of the Victorian Bar and the ABA saying, in effect, recognising and acknowledging what has happened is the necessary first step, but it can only be the first step. The second step is, how do we set about changing culture? I made a set of proposals to both presidents saying But I thought the only way forward that I could think of, others would think of other ways, was to adopt blunt messaging of the kind that has underpinned the drink driving campaign. Drink drive bloody idiot is a message that we all know. It has brought about change in relation to drink driving. And I propose to the presidents of both associations that we need to adopt the same sort of blunt messaging in respect of sexual harassment. Don't touch. Hands off. I think even the dullest student in the room might begin to get an understanding of the message that is being conveyed by that. Don't bring sex into it. Don't say things that are that someone hearing them might think are sexually loaded. Don't ask intrusive questions about personal life, and so on. What I said then, and I maintain maybe a value of adopting that approach, is that it sets the standard. And it is a repeated restatement of setting the standard in ways that are not capable of ready misunderstanding. And amongst the messages was that sexual harassment doesn't shame the victim. It shames the perpetrator. It is the perpetrator's fault. It is the perpetrator's shame. And that somehow this standard setting might begin to break down some of this sense of shame. Couple that with increased willingness to call it out when you see it happen, if you can call it out. And we may begin to change culture to some extent. I hope so. Because at the moment, despite the time I've spent on the subject and despite the discussions I've had with people, I have yet to come up with another way to deal with it. Beyond one fact, which is reflected critically in tonight. Every part of the legal community, you who are just setting out on it, those of us who've been around for longer than Methuselah, all of us have the obligation to set the standard, to keep repeating what the standards are, and amongst those is the core message that sexual harassment shames the perpetrator, not the victim. And we need to get past just hearing the words that are uttered as an excuse and to hear them for what they are. A reassignment of blame to the victim, a reassertion of power over the victim, a re-humiliation of the victim. And when we see through that, then we may begin to see the absolute truth of the core proposition: sexual harassment shames the perpetrator, not the victim.
I think when it comes to calling it out and taking advantage of our positions and in our understandings of these topics, the problem that I have continually come up against in trying to figure out a way to respond to that is the issue that you can be the most well-intentioned person in the room and still not have the words. You can care and you can see it and you can want to do something but not know how to act. And not to speak too highly of the initiatives that the LSS is putting forward this year, but we've begun to develop active bystander training, which will become hopefully a program that is used across the university to ensure that student leaders and therefore then those that belong to their organisations have the opportunity to be taught what to say and how to say it and that they have the opportunity to face up to their own internal issues around how they conceptualise what sexual harassment is. Because sexual harassment, it does not have to be prolonged. The cases that we hear about and the issues that we focus on are often the ones where they have gone to the extent of being continuous and it becomes systematic. But at the end of the day, any instance of inappropriate sexual behaviour is sexual harassment. It can be a one-time thing, or it can be something that happens every day for years. It doesn't change the fact that it happened, and that, as Professor Hayne has said, often it is the victim that has to wear that shame. But we can't hope to actively combat this issue if we don't acknowledge the fact that we don't know what we're doing. Because if you don't know what you're doing, you're never going to act. But if you can sit down and say, I'm not sure, and I don't understand why, and I don't believe these women when they say these things, then that gives us an opportunity to talk about what that means and how we can change that perspective. It's an important part of why men have to be part of this conversation, because they don't believe us, and we know that they don't. But something that Professor Hayne levelled to me, and something which I think is useful to think about in our own understandings of this issue, is, do you have the language to describe an act of that kind to the person sitting next to you right now? If you had been sexually harassed before you walked into this room, could you turn to the person next to you and say with conviction and certainty that what happened was harassment and that you were not okay with it? And if you could not do that in explicit language and in great detail, why do we expect victims of these crimes to be able to do that? Why do we expect them to turn around at the very instance at which it happens and say that I was harassed with certainty and there's no doubt in my mind that I had nothing to do with it? We can't expect that of women. We can't expect that of anybody who is a victim of these kinds of crimes. And so why do we make that the presumption? When women take years to come forward about these things, it's because it takes years to come forward about these things. It takes years to build up the courage and the personal conviction to be able to wear that publicly and to acknowledge that that happened to you, to the same body that you have right now, to maybe a different person inside, but to the same person that you are at the end of the day, and to put yourself forward for criticism and for scrutiny, because that is what is going to happen. And if we don't change the fact that we don't believe the people who this has happened to, if we don't change the presumption that everybody suddenly has the language to vividly describe every sexual encounter they have to a perfect stranger, how are we ever going to acknowledge the fact that this is an issue which goes in silence and continues in silence and is upheld by silence because it is difficult to talk about? And it is even more difficult to talk about when you have been a victim of it. And I think that message is incredibly important, because young women, young men are often not even taught language about consensual sexual experiences, let alone those that we do not consent to. And acknowledging those things, acknowledging what we do not know, acknowledging what we cannot do, is to me the most important step in being able to actually do something. Because that means we're having the conversation, and that is incredibly important.
I commend to you the book that Rachel Doyle has written. It's a very slim book called Power and Consent, I think. Mm-hmm. In it, Rachel Doyle, who's a silk at the Victorian Bar, talks about sexual harassment, talks about her own experiences of sexual harassment and her responses to particular incidents that occurred. Thanks to Rachel and others who were involved in the presentation we did, 5 of us did, for the readers course, Rachel assembled 5 hypothetical scenarios, which we gave to 5 groups within the readers group, asked them to consider what had happened, what responses could have been made, what responses should have been made, how the responses would have been articulated. Those exercises no doubt can be improved, no doubt can be multiplied. but were extraordinarily useful teaching tools for a group of people about to start life at the bar, to recognise strategies that they could employ when they are, as they would describe it, very much amongst the junior burghers. And there are lots of powerful people in the room. How can they speak up? What can they do? And game playing that through was, I hope, as valuable for them as I thought it was for those of us who were participating as supposed instructors. Can I just add one further thing to what Thea has said? And can I direct it particularly to the men in the room? I need you to go away and I need you to think about the following questions. Do you really know what effect sexual harassment has on a victim? You ever thought about that? You ever come to any understanding of what conduct of that kind has on those who are subject to it? Do you understand that some of them leave the profession? Some of them leave the country? Many of them will leave the particular place of employment where these events occurred, despite the perpetrator remaining there. So question one, do you know what effect sexual harassment has on victims? If you don't, go and find out, because you'll be horrified, and you should be horrified. Second thing, you looked at your own conduct? You thought about your own conduct? Do you need to change or modify what you say, what you do? Your immediate response will be, oh no. Just go away and think about it again. Think hard, think honestly. It's very, very confronting when you do that. Have you listened to what women are saying? Have you heard and understood what they're saying? That's radically different from have you listened. Step one, you've got to listen. But step two, have you heard and understood it? Or are you blinded by your own sense of entitlement? I can, therefore I will. Because there is that pervading sense, alive and well at all stages and ages of the legal community. Not just in this state, throughout this country. And that leads on to the final point. Are you a fit and proper person to practice law? I'm no longer in a position where I can decide any of these questions. All I'll say to you is this. Misusing or abusing power in the way in which that occurs in sexual harassment is to me directly contrary to the notion of being fit and proper to exercise the powers of a lawyer. I said if there was to be change in the culture of the profession, it was time for blunt messaging. I can't get any blunter than that.
On all of those things, I think that The impact of sexual harassment on victims isn't always done in conscious choices. We don't always up and leave the country because we consciously choose to run away or that we're protecting ourselves in some form. It comes through in the decisions that you make in the day-to-day that you don't even realise that you're making until they're done. And when you heal and when you look back, you recognise that you curbed your own intentions, that you limited your own potential for fear of it happening again, for fear of blame being put on you for the situation. And in that, we protect men. And that is shameful in and of itself. When you look at your own conduct, you need to be highly critical. And you need to now allow yourself to be wrong. And if you overstep and make a mistake, you need to apologise. Do not think that she hasn't noticed, because she has. And sometimes an apology is all that it takes to ensure that both of you can move forward and heal. I think that being heard as a woman is a difficult thing. And I think that even in an institution like the law school, where we see one another as equals and as peers, we are often not listened to. And I would encourage all of you to take pause next time a woman speaks in any form or in any matter and allow her the second sentence that she has to say. I'm sick of having to explain and then process surprise from my male peers when I detail small instances of sexual harassment. If you are surprised by small instances, you have some serious learning to do. And the resources are there. The women are right there, and they are the ones who can speak the most to it. So create a safe space for them to do that. Come to them and ask them to speak to you and recognise that you are the one that knows less in this space. And finally, on the same point as Professor Hayne, if you will not be a better person for those around you, if you will not change your conduct because you care about others, do it for yourself, because your career is going to end, and it is going to end in shame, because we are here as a generation who are putting our foot down much earlier than has been done in the past. And this is not a tidal wave of change. It is not going to happen overnight, but it is happening. And if it is your own sense of self-worth and your own progression in the legal profession that makes you stop, then so be it. If you're going to be selfish in that instance. And leave everybody else to live their lives unaffected by your poor choices of behaviour. And to all of the women in the room, and to all those who have suffered from this kind of violence, you are not alone. It is not your fault. And we are stronger together moving forward, understanding that we have a voice, and we will be given space and platforms to talk about this issue. And that is very important. If anybody would like to ask a question, if you could make your way to this side, I'm assuming? Yes, over onto this side, you can. There has to be one of you, surely.
Wasn't that blunt?
Thank you for that great conversation. Thea, you made an astute observation towards the end there that this generation are probably going to put its foot down a little bit earlier than previous generations have. And Professor Hayne, I wanted to ask what you think are the factors that allowed previous generations to turn a blind eye or ignore this or sit in rooms where it occurred and not, as Thea said, put your foot down?
I think that explaining why it has happened in the past is not easy. It's not easy because the evident injustice of it should have been a complete answer. It was not. Why was it not? I think that part of the explanation, and not complete explanation at all, is that much of the conduct occurs in private. Much of the conduct occurs in secret. And the victim goes away, has in the past gone away, thinking, oh, that was my fault. And the perpetrator, if ever confronted about it, which did not occur often, sloughed it off with one of the excuses I have described. No one paused to think and listen and hear beyond that. Now, is that a satisfactory explanation? No, it's not. It's about the only one I've got, though. Is it sufficient? No, plainly not. I mean, can I just tackle one side of it directly? The notion of open secret. Open secret is a lovely phrase that appears readily in newspaper headlines. Oh, it's an open secret that this has been occurring in the profession, or it's an open secret that X was guilty of it. That comes to me as a surprise. It really does. And the fact is, and one of the horrors that was brought home to me by the Chief Justice's statement was that during the 10 years I was on the court, I did not see or hear anything that suggested that sexual harassment was occurring at the court. And the horror of discovering that, yes, he'd had more than once with 6 associates was very large and very real. But there we are. It's a fact.
Thank you both for an incredible conversation. My question ties into what Pip Nicholson was talking about right at the start.
I'm sorry, can you speak a little louder? I'm terribly sorry. It's the old man here who's sort of...
My question ties into what Pip was speaking to at the start about how she was looking to recent graduates of this law school and the work we could also do in this space as we move into our careers. And I guess I thought that was a great thing to say, but also immediately started thinking about the hierarchy we would be stepping into. And I know that you both spoke to, such as the active bystander training and the work you're doing with the Victorian Bar, as to how you can start to empower people in our positions moving into the law industry in our new careers. But I kind of wanted you to just speak a bit more to that and address it specifically in terms of us as new lawyers, how we can maybe take the training you are offering and work that into our work as junior lawyers, and maybe even speak to some of the difficulties we may face as well working in this role. Thanks.
I don't care. You go.
Well, I think the thing is that it has to be training on all levels, which, training isn't the answer to everything. We know that because obviously the law says that these things are wrong and we should not do them, and we are students of the law, and yet they are wrong and we still do them. But I think there's definitely a need to emphasise the fact that it can't just be training for students and it can't just be training for new graduates. It has to actually come in and tackle those higher systems of power. But I think that goes to what we were talking about as well, about making people sit down and acknowledge what they don't know how to do. And I think that it goes to the previous question as well, of that intergenerationally, there hasn't been any conversations about what we do and do not know how to do in this space. I'm not sure how that functions on the highest levels, because obviously people gain authority and they gain the ability to be untouchable in a sense and have discretion over what they engage with in terms of training when they are leaders of firms and of the judiciary. But at the end of the day, the lessons have to be the same across the board. And I think that, although it might seem like a simplistic solution, self-reflection is a very powerful tool if it is forced on to people in positions of power.
And can I add this, that I think opportunities to be heard are larger and more numerous than once they were. Certainly within firms, I think certainly within the bar, certainly within the university, it is possible to seek someone out and speak. And one of the inevitable PowerPoints I created to give to the two presidents was one which said, if it seems creepy, weird, inappropriate, offensive or wrong, it probably is. Talk to someone. Sexual harassment is never okay. That is, if you are confronted with behaviour of the kind I've described, creepy, weird, seems wrong, don't bottle it up. Yes, there may be a period when you have to process what's happened and did that just happen, or did I hear what I thought I heard, and you may have to process it for a time, perhaps quite a time. But then go and talk to someone. Soon enough in your organisation, whatever it is, you will recognise that there is someone to whom you can go and speak and say, look, X did this, said this, acted in this way. That was that as off as I thought it was? Yeah, of course it was. Come and talk too. And so it goes. I think that standard setting is one thing I emphasise. But also, if it seems creepy, weird, offensive or wrong, it probably is, speak up. Don't just let it rot there and think, oh, I'll get over that. I've got to let it go past. No, don't. I
think that goes though for as well people who see it in organisations.
Yeah.
I think it's something to remember is that if you see something which you think is creepy, weird, offensive or of some other kind, if you're thinking twice about an interaction that should be minor, then you have a responsibility to take the onus off the victim for having to go forward and say the thing. Because we know that the consequences are there for victims, but they are not there for bystanders. And so use that position as an opportunity to support somebody, even if it is in silence, that they do not know that you have done that thing for them, but so that they maybe cannot have to be victim to it again.
There's a difficult dance to play with victim autonomy. At the end of the day, the victim has to remain in charge, I think. And I think, yes, as the bystander, you have an obligation to call it out. You have an obligation, if you can, you have an obligation to call it out. You have an obligation to go and talk to someone, but you have got to bear steadily in mind that the centre of this has to remain the victim. I think centrality of victim and autonomy of victim is, at least in my mind, critical. Do you think I'm...
No, you're correct.
Yeah.
My question is to both of you. Professor Hayne, you spoke about standard setting and even referenced the example of drink driving seeping into the minds of society. I was wondering if either of you saw the recent government ad on consent with the milkshake.
I admit nothing.
I would love to know your thoughts on this as to whether or not this is good standard setting.
I would like to be given $3 million and I will make you something that probably costs a tenth of that, that maybe actually has some impact with the people here in this room. It is incredibly upsetting that something of that scale was produced and released. And I think it's very telling when you have high school students being some of the loudest voices in criticism of it. It's this perception that the younger generation don't know what's going on. And I think that's something that has changed for our generation and generations below us, is that they know full well what sexual harassment looks and feels like, and they talk about it. And so to have high school students criticising a government campaign around consent demonstrates the fact that they have completely missed the mark. They did not do their research, and they get...
They didn't think.
No.
Just words fail me. No, the original T clip, which I think Thames Valley Police, of all people, put together about 7 years ago, fine. But that thing...
Yes, Google consent and T, and you'll find a very, very straightforward animated video which puts it in such plain language that they give it to primary school students and it works. And yes, the government has a lot to answer for in this space, as we all know, but I don't know what else to say about that.
Thank you very much. I wanted to ask you both a question about the role and necessity of kind of concrete changes. So the first one, Professor Hayne, you spoke about sexual harassment occurring in private. And one of the recommendations from a recent New Zealand report into sexual harassment in the legal profession is that law firms shouldn't have such late work hours because that facilitates harassment, that they shouldn't have after work functions in which there's alcohol, some kind of, maybe not the latter, but the former core aspects of the legal profession and whether that needs to change. And the second, in relation to concrete changes, is whether men need to give up some of their power. So that is, if we look at the judiciary, the bar and partners, it's still quite shocking how few females there are there. And if something like much more ambitious quotas would be helpful in this space.
The disinhibiting effects of alcohol are very well recognised in all forms of offending. Late at work hours don't help. But in the end, until basic standards of respect of one person for another person. Let's leave gender out of it. One person respects another person. Until that idea seeps into the thick heads of some people, we are facing a problem. And for a long time, I think, there was a comforting myth abroad, perhaps at the bar only, but perhaps more generally. Oh, it's just a few old dinosaurs. And just the few old dinosaurs who haven't caught up with what's happening, they'll die out, the problem will go away. No, it's not just dinosaurs. Yeah, there are dinosaurs who do it. But it is all levels. And all levels of lawyer have to understand that we have a massive problem. A massive problem for which there is collective responsibility, but individual responsibility. And give up power? Yes. At the very least, recognise imbalance of power. Start there. Start by recognising that in a hierarchical profession, A is seen as being powerful over B because A is thought by B to be able to influence how B's career will move. Recognise that there's that differential power. Recognising that there's that differential power, be very careful of what you do. Rachel Doyle in her book spoke of running up red flags about conduct. She said there are 3 red flags that you need to consider. Age difference, seniority difference, that is power difference. They're 2 red flags that hit the masthead straight away. And the 3rd red flag, which she said is the biggest of them all, would you be happy if the person to whom you are speaking or towards whom you are acting told another of what you are about to say or about to do? Or are you determined that it should remain secret? If you are determined it should remain secret, you've got red flags at every flagpole on the ship that you can find and them hanging out the portholes. Stop. Don't.
I think on the notion of quotas, I support them in their essence, but we saw when there was higher levels of appointment of female judges that we then ran into the issue of there not being enough female barristers, and therefore there not being enough mentors for incoming junior barristers who wanted to have a mentor of the same gender. And I think that goes back to the point that I made right at the very beginning, that women are not staying in the legal profession as it is. And so although I highly support there being a change in the way the highest levels of the legal profession are structured and who sits in those seats, we don't have people to fill them if we're all getting pulled out before we get there. I know that there are women in this room that I have had conversations with who are in doubt about their choice to pursue a legal career based on the fact that they don't want to have to deal with this. And so if we are taking these degrees and moving into other spaces that are better for us and safer for us, we're not going to ever be able to change who sits at the top because there's not going to be anyone there to do it. And so I think that although quotas and the change at the top is incredibly necessary and it does speak to the whole problem, it's a difficult issue to tackle just on that level. And it has to come into every other element that we've talked about tonight, because if we're not staying in the profession, you can't appoint us anywhere. And I think that's a really big issue.
We have one last question. Given the repercussions that victims still face for speaking up, how do we get other people to speak up when they aren't always aware of what is creepy or weird? And how do we teach them?
I guess I can say something on this immediately. Believe women. Believing a woman doesn't mean that you're going to go and crucify the person that did it to them. It doesn't mean that someone is going to lose their job or that there's going to be mass repercussions. Believing a woman lets her know that she's been seen, she has been heard, and that she has not imagined what has happened. The steps that come after that, the processes in which we deal with these kinds of issues, are incredibly flawed. The legal system in all its precedent setting has worked us into a corner that makes it unthinkable for most women to come into the system in the hopes of addressing their issue. And that's something that has to change on a legislative level, it has to change within courts, and it has to change within society, and that's not an easy task. But I would encourage each and every one of you, if you hear a story or you hear somebody come forward with an incident that they feel was sexual harassment, supporting them in that fact, in their perception of the world, in their experience, enables us to understand more broadly what kinds of things are crossing the line, what kinds of things come in the grey area, and what kinds of things are impacting all of us on the day-to-day. And I think that that belief and that trust and that ability to take a breath after you've told somebody about your experience, but still know that there has to be due process and there has to be things that happen after that fact for there to be consequences, is something that's currently missing. Because the assumption right now is that if you speak up, you have to be ready to damn them to the ends of the earth. And I think that that idea that saying one thing has to mean everything, it inhibits the ability for us to progress in this space and learn more about the issues that are affecting one another.
And it speaks, I think, to the forms of investigation and inquiry that are made when a matter comes to the attention of an employing authority. They don't have to hold a royal commission. They don't have to hold a trial as they would of a criminal offence. Someone has come in to the HR office or the senior partner's office and said, "This happened to me." Well, fairly clear what is said to have happened. Did it happen or did it not? You don't hold a royal commission into it, extending over time, and above all else, you don't subject the person making the complaint to the cross-examination that you might expect in a criminal trial. You're not conducting a criminal trial.
You're having a conversation.
Yeah.
And on that note, maybe we can thank the two of you for the conversation. I'll be very brief because I'm acutely aware that we've broken all the rules of timekeeping. But I wanted to come back to the question that was asked around the agency of people who are young in the sense of, and junior in a hierarchical setting. And I think the questions from this side of the room were fantastic. And the next time we convene, I really look forward to questions from the other side of the room. I did just want to go back, not to take up that broader conversation, but to some comments that were made at the panel that we held last year, where Josh Bornstein, who works with many people bringing allegations of sexual harassment, said there are 4 steps, or at least by the end of the conversation we agreed 4 steps. And he said, never underestimate the impact. Start with your health, and so see a doctor, see a counsellor, start with your health. Then see a friend, a close confidant, a trusted source of advice. So seek counsel from someone in whom you have trust. Ever the lawyer, collate your evidence. And then, when the time is right for you, make your decision. And I just wanted to remind us of those 4 steps, because this was a much more broad-ranging conversation, and deliberately so, and sought not to lay its emphasis on the issues surrounding complaint. But I think the issue was validly raised. There's a hierarchy everywhere we look. How do we step through that with some sense of security? And I wanted to reiterate where the panel landed last year. I wanted to thank our bookends. I think they did a good job. But I think in particular, I want to say this. I want to thank you both for accepting my invitation. I want to thank each of you for your frankness. This is an extraordinarily difficult conversation, and you are both, I think, bearing a great deal in the frankness of your comments, and I congratulate you for that courage. And then finally, each of you is being an activist in your own way on an issue that is long-standing, that is reflective of entrenched and systemic sexism and power imbalance. But activism is a critical part of the steps through to resolution, and I congratulate each of you for having it. Thank you very much.